Hello. I'm Vince White. I'm an employment attorney on this channel. On this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We just went live. It's 5 p.m. Eastern Time on the 21st of February, 2025. We have 6 people concurrently. No questions yet. No questions yet. Very sad. I need questions to answer, folks. I need questions to answer. Otherwise, my life has no meaning. Wow, YouTube user Secret Dad. Secret Dad. Secret Dad, does that mean like you're a dad with secrets? Or are you secretly someone's father? Hello, Mr. White. I love your content. I love your taste. Can my employer deny me access to human resources to report discrimination? I mean, they can, in the sense that, like, can you murder someone? Sure. Is it illegal? Absolutely. Same for HR. Corporate informed me that they are not allowed to give me a phone number or email to HR. Okay, so that's great. You have a great futility argument. They won't give you access to HR. Go ahead and take your case, excuse me, and get it filed with an employment attorney or with a, federal or state agency. They're just trying to dissuade you from reporting. Very foolish on their part, if I'm being honest. Very, very foolish. But that, listen, they can be stupid if they want. I would recommend you speak with a local employment attorney right away. Right away. Okay, we have 15 people concurrently. We have 4 likes, 17 people currently, and 4 likes. Remember, it is free to like the stream. It is how the algorithm sees us. So super helpful. We answered the only question we have right now. So I'm going to tell a story really quick to kill time. I had a buddy visit this week. Had a friend, an adult friend, a gentleman. Made it sound weird. Just a friend. Visit. He brought his kids. I took his kids skiing. And I went skiing with his son for a couple of runs. His son was, like a second time ever skier. And I was talking to him. I was like, all right, like he was, he could turn, he could pizza wedge. I used to be a ski instructor in college to like pay my way through college. I had a lot of jobs. I drove a bus to get through college. I was the only Rolex dealer in the county. And I worked as a ski instructor. I actually taught phys ed courses for like Cornell University and stuff, like ski phys ed, stuff like that. So I was like trying to help this kid go from like pizza wedging, which is a kind of, beginner skiing, to skiing parallel. And I was talking to him. And I was like, all right, buddy. So last time on that green, you got a little scared. You forgot to turn, but I know you can turn. And like when you turn, that's how you slow down. So like you're not gonna like end up in the nets again, because that's what he did. He like crashed into the nets. You're not gonna end up in the nets again if you stay calm and you make your turns. And he mutters to me, he's like, I'm not your buddy. 12 years old. 12 years old. I, in my mind, was like, I'm in the scene of Zoolander where they're like, I'm not your bro. Like, it was kind of wild. And I didn't really know what to say to him. And I was just like, all right, I apologize. If you don't want me to call you little buddy, or buddy, that's fine. I get it. He's like, yeah, call me my name. And he like said his name. I was like, okay. All right. I don't know. You're such a tough guy. I think I'm gonna have to call you little man. Turns out he preferred buddy, but we did get him skiing pretty well. So progress, definite progress. All right, we need more questions. We only have 1 question so far. Anybody else have a question for me? Oh, Secret Dad says, thank you for the helpful information. I was told to give my manager my complaint, but he is the one doing this to me. Isn't that like asking a bank robber to turn himself in? It absolutely is. What I would recommend in that scenario is put a written complaint in and give it to the supervisor above your manager. But like do it in writing, ideally in an email, timestamped by a third-party service like Gmail, something like that. That way you can keep evidence that you complained if you have to make a retaliation argument later. And don't complain to the bad actor directly. That doesn't make any sense. Complain to his manager at least. So listen, that's fine. As long as you have someone to complain to, it's better than nothing. But like do it in writing, because they are acting funny. Okay, Madeline Stevens, YouTube user Madeline Stevens says, how would you respond to the claims made in the defense's summary? My former employer included like a book before actually stating the response to the the response to the claims. Madeline, if this is in a position statement at the EEOC level, we have a rebuttal writing 101 video that I think would be tremendously useful. In that scenario, if you are talking about, I think that's probably what you're talking about here. Yeah. So we have a video entitled, I think, Rebuttal Writing 101 that is going to do a way better job. I think it's like a 20, 30-minute video setting out kind of a strategy for approaching your rebuttal writing and how to address their position statement. And I suggest watching that video. Yeah. HRC, I mean, listen, it's a generalized video, so the information is largely going to translate to HRC. So check it out. I think it's going to help you. Excuse me. I gotta shake this cough. Yeah, check out that video. Oh my gosh, Madeline, thank you so much. You don't have to tip. Thank you for the $9.99. That's so kind. And if you have more questions, please don't hesitate, because I cannot stress enough, you don't have to give me money. YouTube user Pamaroon says, Pamaroon is a longtime viewer of the channel. Who do you sue if one has a sealed conviction record and was unsealed when doing a job search and they were not offered employment? Well, I mean, I guess there's probably two potential options there. Sounds like somebody messed up by unsealing that record. So you might sue whoever messed that up. The other person you would sue is if you experience criminal record discrimination, you would sue the employer because they're discriminating against you based on the basis of your criminal record, right? So that's certainly a claim under federal law. Always, check the details, but check with local counsel. Excuse me, I'm like choking here. But that's who I would sue. Viral Shedding Zombie says, Vince is already a zillionaire. I am not a zillionaire, nor even a billionaire, but I am comfortable. Thank you for noticing. Claudette Owen says, the federal agency did not... Hold on, let me blow my nose here. Oh, Claudette, you retracted your message. I can't answer it now. I'm out of questions because Claudette retracted her question. iTube says, if my coworker was able to keep their job after submitting their FMLA claim late, but they fired me for the same thing, could that be discrimination even though we have the same disability? Well, maybe. I mean, just because they did right by one person doesn't mean they're necessarily not going to discriminate against you. It does make your case more complex. I'll be upfront with you that makes it a little bit tougher, but I don't think it kills your case. YouTube user Ace says, recently got called from the ethics officers about my long breaks, lunches, sometimes not clocking out or not at all of the lunch. A few times I would leave after work, but come back 1 to 3 hours to clock out. I'm scared AF. I'm still working, but waiting for them to tell me what they want me to do. So Ace, listen, if you can get the money together to pay them back, I don't know how much you owe them or how much you stole from them. My advice is talk to a criminal attorney and follow their advice. YouTube user Poll Girl 2011 says, hi, Vince. Hi, Poll Girl. How does it work when you have multiple claims with different agencies and they have back pay rights? Can you explain how that works? So listen, talk with your attorney, local counsel, always controls on this, have a conversation. Usually the pool for back pay is the same for all the claims. We have the chat jumping ahead. So like if you have like 10 claims, all of which address the same economic damages for the same period of back pay, if you win, 100% of that back pay in one of those claims, you might not have that same pool of damages in the other claims, but check with your attorney, check with your local counsel. YouTube user Pamaroon says, but if you disclose that you don't have a criminal record, which sealed applicants can do, then it seems like the person lied about said conviction on the application. Right. So I know they can say that you lied, and that's an argument, which is why you might want to sue the person who incorrectly unsealed that conviction. But the reality is that that was a sealed conviction, so you're allowed. It's not a lie. You accurately reported you don't have a conviction because it was sealed, and you can say that, right? So I think there's still the potential for criminal record discrimination there. Although, listen, it is complex. To your point, it's a very complex case because there's technically an inaccurate statement on the application, which could, be construed as a lie, and then you have a problem. We have a question from YouTube user Harlem World. I thought I was going to read it Harlem Worldwide, baby, but it's not. It's just Harlem World, baby. I filed a lawsuit. Harlem, your username would be better if it said Harlem Worldwide, baby. I'm not sure why. I just think it'd be better. I filed a lawsuit in the federal court pro se. The defense attorney reached out to me for a settlement conference. We agreed now. She is sending me a settlement agreement. What are the next steps? Well, you review that settlement agreement. If you agree on all the terms, if that settlement agreement meets with your needs and it does what you need it to do, you would execute that agreement and make sure you understand when and how payment's going to take place. And you'll be done, potentially. That relatively simple. Good job on representing yourself pro se and getting a settlement. You're welcome, Po Girl 2011. Pam Maroon says, since internships are more like employment from hire to possible fire, what are the employment rates for collegiate interns? So 99% of interns should be paid. Any paid intern has all the same employment rights as an employee. If you're paid, you have the rights of an employee. Now, if you're an unpaid intern who's getting college credit or something like that, that's its own animal. It's going to be very driven by the circumstances. But any paid intern has the same rights as any paid employee. YouTube user CO says, is that CO as in commanding officer? The federal agency didn't ask for interrogatories, requests for documents, or admissions by deadline. What does it mean? Do they think they can win with the ROI, or did they drop the ball? I don't know. I don't know if about your situation. They might, listen, it's entirely possible they think you failed to state a cause of action, so they don't feel like they actually have to litigate the case. That happens. It's also possible they just dropped the ball. A lot of the federal agencies, the representation is not good. The federal government, I'm not trying to be all doge about it, but like, there's a lot of people in the federal government who don't like to do their job. And, it's entirely possible the attorney representing the agency just chose not to do her or his job. YouTube user Gabriel says, do most settlements happen before or after a trial date is given? So settlements happen, Gabriel, all the way through cases. I would say overwhelmingly, most of our cases settle in the first 9 months. So I guess technically most settlements happen before a trial date is given. Although the biggest settlements often happen after a trial date is given. So be aware of that. YouTube user PoGirl2011 says, how significant is it if the state commission finds probable cause and it's in legal review? Okay, so if you're getting probable cause from the New York State Division of Human Rights, which is the agency in the state where I'm embedded, what it means is you're going to get a hearing. You're going to get a 2-day hearing from the state division. So that is very significant. You're also going to get some settlement conferences, some pretrial conferences. You're going to get an administrative law judge assigned to handle those conferences. And then probably a different administrative law judge will handle the actual trial or the hearing itself. YouTube user SilverDog5280 says, I am choking here. SilverDog5280 says, after I wrote a rebuttal with evidence, my attorney said it's their policy to not file a rebuttal as they don't want to disclose evidence and the civil rights group doesn't do much. Does this make sense? Why? Okay. So if you plan to go on a federal court, you might not want to file a rebuttal because you might want to hide some of your evidence for later in federal court. That is certainly possible. We do that occasionally, although I'll be upfront, we do it in 5% of cases. excuse me, it's often cases where we think the employer is lying, or we can show the employer is lying. We have evidence, and we don't want to like waste that on the rebuttal. So it can make sense. Doesn't mean it necessarily makes sense for you. It might not. I don't know your situation, but like it could. Ace says, would it be wise to quit and go ghost? I feel like I killed someone, stress so high. So Ace, it really depends on how much you owe them, right? If you owe them like 30 grand, talk to a criminal attorney. If you owe them like $500, you're fine. They're not going to sue you. They're not going to sue you. They're not going to press charges, probably. I can't tell you the future. I could be wrong, but like realistically speaking, most of the time, they just do nothing. YouTube user Acasioli says, my attorney drafted the New York State Division of Human Rights complaint. I have an issue with one of the people listed as discriminating against me because she just accepted my incident reports. Should I have my lawyer remove her? Sure. If you don't think that person did anything wrong, have that conversation with your attorney. There's no reason to sue somebody who did nothing wrong, right? Like you don't have to like blame people who did nothing wrong. We're not in the business of hurting people to make money here unless those people did bad things. If those people did bad things, they discriminated, they sexually harassed, they retaliated, well, we're going to mess them up, right? Stacking bodies, stacking checks. But like, if she did nothing wrong, fair enough. She's the bystander, you know? We're not here to hurt innocent people. AGG, Eggtown, I'm going to assume you mean agricultural town, although I suspect that might not be the case. Employer did not show up for the appeal in Texas. I was fired for misconduct. The appeal board overturned the decision saying the employer lied. That's awesome. Congratulations. Poll Girl 2011 said, if in legal review, do you suggest that I hire legal counsel or just let the commission handle it? Poor Girl 2011, if you can obtain counsel, I always suggest counsel. Yeah, if you can get an attorney, do. Never, in my opinion, never let the State Division of Human Rights represent you. YouTube user Pam Maroon says, how does the Doge, is it Doge or Doge? I don't know. The Doge layoffs change the representation of employment law, and how is your firm planning for it? So as of right now, the big change is for people with gender identity issues who are, transitioning or being targeted based on their gender identity. That's the big change on the federal level right now. Beyond that, the EEOC is largely the same as it ever was. We had a video we filmed today. I think it's coming out tomorrow about some new things the EEOC is doing. But realistically, the EEOC, I always misquote the numbers, but I think they brought like in 2023, 80,000 cases or something like that. 80,000 cases were filed with the EEOC, and the EEOC filed like 56 litigations. That's shocking. That's a shocking amount, right? And my point is like, oh no, don't defund the EEOC. They do so much for victims, but they don't. They don't. They're an obstacle in many ways. And there's ways we can use them to get free discovery and to help our clients. And they're not useless, but they're not like out there fighting in the trenches for you either. You know what I mean? Like, it sucks to see them get their wings clipped and see a bunch of people get terminated. But, if the EEOC had done more good, and it's, listen, it's been underfunded and understaffed, and there's lots of issues through many, many different administrations from both partisan parties. So I don't always blame the people at the EEOC, although frankly, sometimes I do. A lot of them are not very caring or competent, but I'm not too worried about this administration, if I'm being honest. If they got rid of the EEOC and I could just file my cases straight in federal court, cool. Sounds great. Less hoops to jump through. Ace says that allegedly Ace might have absconded with $3,000 to $6,000 from his or her employer. I'm scared. I'm 25 and I never committed a crime before. Ace, I think you're gonna be fine. That's like $6,000 is not enough for them to like sue you. Probably, it's probably not enough for them to press charges against you. I would say, listen, if they come after you for the money, ask for a payment plan. You'll probably be fine. But if they do come after you, get a criminal attorney. Rebecca Baldass says, counsel. Blow my nose. All right. Counsel. My agency falsified my payroll and paid me while being on lockout while I was on lockout from my agency. LOD for over $7,000 due to this falsification. I told them to cease and desist while they did this. Thus, this was their attempt to stop my unemployment. That sucks. That is a tough situation. Silver Dog 5280 says, I filed a complaint for age discrimination and retaliation. I am still employed. My attorney is advising me to keep working. The work environment is tough. Do I hurt my case by quitting? The answer is potentially yes. You do hurt your case by quitting, and I'll explain why. So if you resign, you kind of have to make a constructive termination argument. Things were so bad that I felt like I had to resign. That's an argument you can make, and it lets you keep growing your economic damages if you're successful, but it's a kind of a higher risk argument. Now, if you stay, I know that's tough, but if you can stay, if you can stomach it, if not everybody can, if you can stay and someone retaliates against you, then your case value goes up, right? So consider that, if you can stay, it's a good option. Rebecca Baldass says, can I add the $7,000 line of duty to the damages in my case? They tried to give it to you, Rebecca, and you turned it down. I guess if that's money you're owed, you can certainly add that to damages in your case. Why not? YouTube user iTube says, can unclear company policies be valuable if that's a big reason why my coworker and I were late on our FMLA claims? I have multiple witnesses to state MDA policies aren't available on the company's site. Maybe it might help your case. It might be useful evidence in your case. YouTube user CO says, if the selecting official admits he gave an unauthorized preference to an individual during the selection process, does that help to prove discrimination if the individual is not in a protected class? It could, yeah. So, listen, showing something was unfair does not in and of itself show discrimination. But if it's unfair and you're in different groups, like one's in protected class, one's not, there's some level of assumption that the protected class could have played a role, right? YouTube user Kazioli says, thank you for your response. I was confused by my lawyer telling me she was involved, played some part in my former employer's actions from the onset of me reporting the discriminating remarks. Thank you. I was confused by my lawyer telling me she was involved and played some part in my former employer's actions from the onset of me reporting the discrimination remarks. Thank you. Well, how is she involved? She was involved before you hired her? That I have questions about. Like, why? Like, how is she involved? Who is she representing? What was she doing? Is it a conflict of interest? Like, why is she representing them and now she's representing you? That's a problem. I have questions. Nacho Biz. That is an incredible username. I'm glad you finally caught it live. Okay, YouTube user LC. If I didn't include defamation in my EEOC charge, can I include it in my lawsuit? Sure, you actually can't include defamation in your EEOC charge. You can describe defamation in an EEOC charge and say it was motivated by discrimination, but you can't bring a defamation claim before the EEOC. They don't adjudicate defamation claims. They adjudicate discrimination and sexual harassment claims and retaliation. YouTube user CC. So yes, you can bring that in your lawsuit now if you want. CC, are administrative law judges for unemployment cases actual judges, or are they lawyers who are filling the role in name only? Do their opinions hold any weight in a lawsuit? Oh boy, you're going to get me in trouble. Okay, so administrative law judges are not all created equal. When you ask what they are, it's in the name. They're administrative law judges. So there's an administrative law that creates a specific kind of judge who only has power in a specific situation, right? So unemployment court, the New York State Division of Human Rights, Workers' compensation courts, things of that nature. Are they judges? Well, I assure you, they are administrative law judges. Well, what's that? Is that a real judge? It's an administrative law judge. Does a judge sitting on the bench of the Supreme Court of New York think that administrative law judge is on the same level as that judge? No. Does a federal judge in federal court think that administrative law judge is on the same level as a federal judge? No. But I'll tell you what, a federal judge sitting in federal court doesn't think a federal magistrate judge is on the same level, doesn't think a state court judge is on the same level, there's a lot, there's a hierarchy, right? So are they judges? Yeah. Are they also attorneys? Yeah. Most judges are also attorneys, right? If you go to traffic court, you might have a magistrate who's just an attorney, who's not even really a judge, depending on where you are. So, it's like different levels. Doesn't make them bad, and it's, when I sit in as an arbitrator, do I think that I'm more powerful than administrative law judge? Sure. Yeah. Because as an arbitrator, I can decide all the claims before me, no matter what they are. If you bring those claims to me, I am the decider, as they say, right? If you're an administrative law judge and claims come to you, you can only decide the claims that are subject to the administrative law that gives you your judgedom, right? Your title. So they're very limited in that fashion. So when I sit as an arbitrator, I'm like, I got more power. I got more power than administrative law judge, and I feel great. But also, frankly, when I sit as an arbitrator, not for nothing, I'm harder to appeal than a state court judge. And you can make the argument I'm harder to appeal than a federal judge sometimes. So do I think I have the power of a federal court judge? Well, I'm not going to serve a lifetime appointment, and I can't send the marshals to come and get you. But if I make a decision in your case, odds are it's going to stick, right? So there's an interplay. Different kinds of judges and arbitrators have different levels of power and different like little mini powers. So it's, I think Pamaroon is bullying me. I see her referencing my coughing. It's okay. It's okay. YouTube user Kelsey, hopefully not Travis. Is it crazy for a defendant to leave deposition before it's over with the excuse that they have to pick up their kids from school? Yeah, it's crazy. It definitely happens. And you can just demand another day of deposition if they did that. Pamaroon says, on a personal note, you have a possible underlying medical condition. Don't be a typical guy and ignore it. Health is wealth. # coughing. Pamaroon, I will catch you up on this. So, as you know, as you may know, I had stage 4 cancer way back when, about 10 years ago, and the radiation was on my neck. You can see I'm missing like a third of my neck here, and I had a lot of radiation and chemo, and there is some damage to my neck from all that, and that is what's causing the coughing. I tried a couple different medications for it, and this week I'm going to schedule, I think an endoscopy where they put stuff down your throat to see what's going on. So I am treating it. Thank you for your concern. You're a bully. I'm kidding. Poor Girl 2011 says, can it be considered constructive discharge if terminated while on sick leave related to failure to accommodate case with a probable cause? Can it be considered constructive discharge if you were terminated? You don't want to argue constructive discharge. You were terminated, right? I mean, a true termination is better than a constructive discharge. So you were terminated. Just go with that. YouTube user Akazioli says, that was an extension from my earlier question. Sorry, Akazioli. The way the chat works is you kind of got to ask your question in one block. Otherwise, I'm going to have trouble reading it all together. TJN TV says, hey, Vince, my initial disclosure were drafted in about a week ago after the defense was served with the lawsuit. They hired a firm that specialized in arbitration and settlement. What do you think this means? I think it means that they either believe your case is going to arbitration or that they're cutting you a settlement check. YouTube user Nacho Biz says, Vincent, we chatted on email. Let's talk about freelancing. Okay. I'm not. Are you trying to freelance for me, or are you want to talk about the rights of freelancers? Let's see. Oh, you have a question about freelancers. Let me blow my nose again. Okay. YouTube user Nacho Biz says, it seems like freelancers have zero rights and can be abused by the people who hire them and the platform. I also like to talk about the site gaming its freelancers. Are the jobs even real? Okay, so I feel like you're talking about like Uber Eats or Uber or Grubhub or, one of these, maybe like handy.com. You are largely correct. So the way the click wrap agreement is structured, the freelancers have very few rights. Now, there have been efforts in places like California to get rid of those freelancer positions and make those people employees. Those have had mixed results. Are the jobs even real? I mean, listen, there's labor that gets done for compensation. So that's a job. The question is the job handled in a respectful and humane manner? And is it properly compensated? And I know this is a topic near and dear to your heart, but like, there's not a ton that a firm like mine can necessarily do. This is more the purview of politicians making laws to protect those freelancers. YouTube user Carly says, do wage and hour attorneys work on contingency? Overwhelmingly, yes. My friend found out that the NYC manual workers are supposed to be paid weekly. She's working 10 hours for a major retailer and is still getting paid bi-weekly. Oh, she's working 10 years for a major retailer and still getting paid bi-weekly. I mean, is it a manual? If she's working for a retailer, it might not be a manual labor job. So check into that. Most retail is not considered manual labor in New York City, but it certainly could be. If you have like a warehouse job, I could see that being manual labor, or like unloading trucks, or, I could certainly see it being a manual labor job. Yes, wage and hour attorneys do overwhelmingly work on a purely contingent basis. YouTube user Boring. I actually had a friend many years ago who, when his wife would tell him things, would just like look at her and say, boring. They're divorced now, but they're both lovely people. Don't tell your spouse they're boring, even if they are. I presume there's something you love about them. Think about that before you tell them they're boring. Quick, we have 51 concurrent viewers, but only 21 likes. Those likes are free, people. It's free to like the stream. And it's how the algorithm sees us. So don't be afraid to help us to help more people just like you. Okay. YouTube user Secret Dad says, are text messages a viable source of evidence? Absolutely. Text messages are one of the most valuable things that I've ever dealt with in my life. They have bought me cars and trucks, plural. I reported misconduct after being suspended, and I was told via text to shut up, basically. That could be really valuable. Share that with your attorney. YouTube user Jada Great, J-DA-GR8. I was fired while on workers' comp. Afterward, my doctor released me to full duty. How long should it take to settle my case? Well, I also lawyered up and filed with the EEOC for disability discrimination. Great. So I'm the kind of lawyer that handles the EEOC. I'm not the kind of lawyer who handles the workers' comp. Those are two different fields. So if you ask me a workers' comp question, one, I don't know what state you're in. Two, I'm not a workers' comp attorney. If you lawyered up and you're a workers' comp attorney, novel concept here, that person's paid to answer that question, and that's what they do for a living. They should get you to answer that question. I'm a different kind of attorney. I do the EEOC stuff, so it's a little bit different. I don't do comp. I did like a summer in workers' comp because I was dating a very nice woman whose father was like the workers' comp attorney for the NHL. And he like called up a firm and was like, hey, this kid is like an embarrassment and he's dating my daughter. Can you give him a job? And they just did. They just gave me a job. It was amazing. But not an amazing job. I don't like comp. It's not like, it's fine, but it's like a volume practice. It's not complex litigation. It's not the big show. It just doesn't really suit me. But it's great. And they're great litigators. YouTube user Ace says, thanks for the help. This company makes millions a year in aerospace. I just feel so ashamed taking advantage of a chill boss. I've been there over a year and a month, maybe billions a year. Yeah, Ace, listen, we all did stuff when we were younger. You said you're like 25. Like, listen, is it is it shitty that you went around stealing time and your boss was chill and like your boss is probably getting screwed by this? Yeah, it's shitty. Like you should feel shitty about that, but like it's not the end of the world. The whole way the human existence works is like we're young, we're real dumb, we make a lot of mistakes, and then we learn from those mistakes and we get less dumb slowly over time. The only real failure is if you don't get less dumb over time, right? I'm not saying you're dumb. I'm just saying, it's going to be okay. Scott Niebarger says upper endoscopies are a fun experience. I think that's what I'm having. I think I'm having an upper endoscopy. What do we got here? Nacho Biz says advents in Upwork. I'm not familiar with Upwork, but I assume it's the same thing. YouTube user CC, the administrative law judge decided favorably towards me and stated clear retaliation and a hostile work environment. Federal judge refused to put any weight on the submitted evidence during summary judgment. That sucks. I'm really sorry. CC, I was happy to reply. My pleasure. YouTube user says, Vincent, they hold your fund and gain interest. That does seem like a crime to me. Silverdog5280 says, I filed complaints with the Civil Rights and Department of Labor for wages. We're in the process for civil rights. My attorney advised me not to tell about the wage claim until investigation is open. Why not? I don't know. I don't know why your attorney said that. Doesn't mean it's bad advice. There might be something in your situation where that makes sense. To me, I don't fully understand what that is, but I'm not your attorney. I don't know your case. So like, I don't want to like step on your attorney's toes. Excuse me. Doug Brooklyn says, do you play StarCraft? I challenge you. Doug Brooklyn, you've opened up a bit of a can of worms here. So I do not play StarCraft 1. Oh no. And I do not play StarCraft 2. I play StarCraft Brood Wars like a gentleman of culture and taste. I played it for many, many years. I started playing when I was 12. It led me to meet a lot of really great people. When I applied to college, I mean, I didn't apply to college. Essentially what happened is like, I had a girlfriend who was like, hey, you're a loser. I'm going to go to college. I think you should apply to the college I'm going to. And I was like, yeah, I don't know about that. I think I'm just going to go ahead and like lay cable for the cable company. And she was like, oh yeah, no, that's not what you're going to do. I had a bunch of StarCraft friends who I played StarCraft with who like went to Cornell and MIT and like, amazing, super educated people who were like, let us write your essays. And they didn't write my essays outright because that'd be plagiarism. But they sure helped a whole bunch. And essentially like these guys like got me into college, and then I was trailer trash. Like I didn't really have a lot of, I didn't put a lot of value on education or things like that. And these guys who I play video games with taught me a lot. Ended up going to Asia. I played some StarCraft in Korea. It was a really big thing for me, and it helped me learn a different way of life, which is like an insane thing to say about a video game. But I'm still friends to this day with the people that I played StarCraft when I was 12. Like we still hang out. We play video games together. When I throw a birthday party, like some of them will fly across the country or across the world, frankly. When I lived in Japan, I saw a lot of my friends who I used to play with in Korea and Asia. And it's a great group of people. It's very diverse in terms of race and walks of life, but it is primarily male. That's always the downside with older video games, right? Not that I'm like, oh, they're men, but like, diversity is a good thing in your friend group. So yeah, I play StarCraft Brood War. Not really anymore. I currently, I had some friends. You're probably familiar with Riot Games. Some of the people who began Riot Games are like personal friends of mine, and I play a lot of TFT. League of Legends TFT. So that's what I play these days. It's fun, and it's more not. I'm 42 now, a little slower. So I prefer games without the same APM. I don't have the same actions per minute that I once had. YouTube user Pam Maroon says, thank you for the shared context to your coughing. Glad to know you're following up. Me no bully. Pam Maroon, you're absolutely a bully. I believe you called me cheeks on a variety of occasions. You are actively a bully. YouTube user Cassioli says, how long will it take my former employer to see the complaint after I send it to the New York State Division of Human Rights? Probably 6 weeks. My best guess. AJ SoFly69 says, I have a case in investigation stage filed in July of 2024. The only thing the attorney did was write a rebuttal without my input to the position statement. Would they bill me for that if I fired them? I mean, listen, I don't really understand how they could write a rebuttal to your position statement without your input. That to me is a little bit sketchy because you lived those events. And the first thing I would want is your thoughts. I'd want you to read that position statement and give me your thoughts so I can go ahead and draft a rebuttal. So that's sketchy. I don't know if they're going to try to bill you or not. I don't know who they are. I don't know what lives in their hearts and minds. But like, if somebody in my firm drafted a rebuttal without talking to the client, they'd be packing their cardboard box, and I would not be billing for that. But that would never happen here, for the record. Mississippi Second Amendment guy says, my case is in the APR process, and my old supervisor is coming to my new job complaining to my boss that I chose not to talk to him. He is the one who sexually harassed me at the old job. What can I do? I would amend your case to add the retaliation because your bad actor from your old job is coming to try to poison your is coming to try to poison your new employment. Certainly. AJ SoFly69 says, uh-oh, why are people giving me so much money this week? We have a Silver Dog says, oh my gosh, Silver Dog gave me $10. Let me like that. Silver Dog, you don't have to give me money. I appreciate it. And it's really nice. It helps the algorithm to see us, but you don't have to give me money. It's very kind. Thank you. My goodness. People are so generous. What do we have here? Kansas City News says, can you sue employees? Yes. Depends on the context, but if you're just asking generally, can you sue someone who's an employee? Yes. Very, very congested. I apologize. Okay. What do we got? YouTube user Bo Ring says, hi, I'm a union employee and my union leaders regularly collude with management. Does the role of an employment attorney in a retaliation case include forcing my collective bargaining agreement terms? So technically, enforcing a collective bargaining agreement is not the purview of an employment attorney. It is the purview of a labor attorney. Now, that's a bit of a false distinction because there's so few employment and labor attorneys in the world that you'll find most employment attorneys also take on labor work because there's so much labor work that goes unaided. Now, can you hire private counsel to force a CBA is going to depend a little bit on the jurisdiction you're in. In New York State, you can, but it's very complex and very expensive, but you can. And I've done it. Ace says, thanks, man. I hope so. I'm over here feeling like I killed someone. Ace, I get it. You're feeling all the right feels. It's going to be okay. I get it. I get why you're upset. I get why you feel bad. You took advantage of someone. Make it right. If you really feel bad about it, approach them and be like, hey, can I get a payment plan to pay you back? My manager's awesome. I'm sorry. And that's fine. Talk to an attorney. Don't just do something because I said it on the internet, but that's a good approach. Silver Dog 5280 says, thanks, Vince. You rock. Silver Dog, you rock. Thank you again for the $10. Excuse me. We have a bunch of retracted messages here. Second, Sex says, how responsible is an employee when they hire an outsider to conduct HR? The firm forced us to divide ourselves by characteristics. I was the only Latina and felt coerced to out myself as bi. Yeah, so I never understand this when employers do this. When employers are trying to force people to what's your sexual orientation or what are your preferred pronouns? Because not everybody, listen, everyone should respect people's preferred pronouns without question. But not everyone who has preferred pronouns is ready to disclose those preferred pronouns. it's one of those things where like it's really hard to be a person who's dealing with gender identity issues in the United States right now. And you might feel like I do have preferred pronouns, but I don't think it's worth it to me personally as an individual human being to use them in the workplace. But then you'll get employers who go around and be like, all you better put your preferred pronouns in your email signature or else. Okay, I see that you mean well, but like statistically speaking, most of the people who have preferred pronouns that are non-standard may not want to disclose them in the workplace based on my understanding of the data. So like if you're like there's a bunch of like straight cisgender males, generally Caucasian, who go around and be like, yeah, everybody's gotta give me the pronouns. Give me your pronouns. You don't. They run around like white knighting, right? Like, give me your pronouns, or you're a bad person. And they'll like do this to people. Who are like, yeah, I guess think you're doing this for me, but you're harming me. Like, I will share my pronouns when I'm good and ready, Mr. White Knight, and you just slow your roll. Like, this is ridiculous. And so like employers will do this. And I think it actually creates liability for them in a variety of situations, including like here for you, they made you disclose that you're bi. You didn't want to. You feel isolated and coerced now. That could be the basis of a claim at some point, right? So like, why did they do that? So they could make an argument about like we have good diversity numbers. Okay, listen, I like diversity, but I don't like it as a numbers game. I like diversity because like inclusion matters and diversity is good for business, right? But running around trying to hit a numbers target by pressuring your employees to disclose things that they don't want to disclose is dumb and creates liability. I mean, very foolish. Jada the Great says, I'm in Alabama. The EEOC accepted my case. I have a very strong argument with text and doctor's letters. What's the probability of them settling? Well, Jada the Great, I'll tell you that about 98% of our cases, a little bit more than 98% of our cases, resolve without going to trial. So I think the chance of a settlement's a good thing. It's higher if you get representation. What do we got here? Chat jumped ahead on me. Carly, YouTube user Carly says, if your employer deletes or edits footage of your assault, sexual harassment after you made a complaint about your supervisor saying racial slurs, is that retaliation? It's evidence tampering. It could also be retaliation. How can you prove this in court? Well, you got to get the evidence and have an expert witness look at it to see if it was tampered with. YouTube user Kenneth Blake says, should I or should I not go with an attorney in mediation? Kenneth, easiest answer here is I have a family member who went through a case like this. She was sexually harassed. She's my little sister. And we got her an attorney for mediation. No question. If you don't want to give that attorney a percentage, you can always pay them hourly. But that being said, like always hire an attorney. Doesn't have to be me. Shouldn't be me. Go talk to local counsel. But like, because we're a little bit expensive, right? Get an attorney if you can. YouTube user 115 Matco says, is an FMLA case worth pursuing if your lost wages and damages were limited to a few months out of work? I mean, it's up to you. Maybe. Like, listen, I don't know what a couple months of work is to you. Like, I've talked to people today where a couple months of work is, we'll call it 3 months, is like 12 grand. And I talked to people today where a couple months of work is like 400 grand, right? So like, that's a very different calculation, depending on those two numbers. It's also different to you. Like, do you care about filing a case in federal court? Do you care about your name being out there? Do you care about the time it takes for you to hire an attorney and get that attorney up to speed and then work with that attorney towards the case? Like, these are all questions that are kind of more personal to you. If you're asking me, would an FMLA case with a few months necessarily be worth my firm's time? The answer to that is if the few months are worth more than 40 grand. I would say that's probably worth my firm's time. That's just, dollars and cents answer. Choose Compassion, YouTube user Choose Compassion says, heart, lightning bolt, wrench. Hi, Vince. Hi, chat. I believe Choose Compassion is one of our intrepid moderators. Choose Compassion, thank you so much for being here to moderate. I appreciate you. You are wonderful. YouTube user Corey, I have 90 right to sue. If I file my case, do you think they will try to settle before the trial date? No attorney will offer me. No attorney will. Oh, no, you have no attorney. Will my offer be at least my back pay? So, Corey, I don't know what your offer is going to be, but yeah, I think there'll probably be some talk about settlement before your trial date. That's very likely. YouTube user Jets. Ooh, are you a Jets fan? I'm so sorry. I'm a Bills fan. I feel your pain. We've been there. We had the drought. We had a 19-year drought. It's going to be okay. I don't know who your quarterback's going to be, though. Jets says, hey, Vince, my lawyer has been trying to serve the HR rep with a deposition subpoena, and it looks like he is avoiding service for deposition. Can we proceed with trial without his evidence, without his testimony? Thanks. Yeah, of course you can. Listen, you might want that. It might be really important evidence. You might not want to, but you can proceed to trial without deposing someone, certainly. Excuse me. YouTube user Justin says, hi, Vince. Have you heard of a case where you settle in the EEOC, the employer hasn't paid, then made a position statement full of lies? What happens if I don't rebuttal them? Listen, I've certainly heard of cases where you settled and the employer then doesn't pay and you have to pursue them. I don't know why if you settled, the EEOC would accept a position statement. That's very strange. Do you have a written settlement agreement, or like what happened there? Like when you say it's settled, how settled? What happened? YouTube user Corey says, can discrimination come in the form of different write-ups that other races would not get? Yes, that is called a disparate treatment discrimination case, Corey. That is absolutely a claim. Excuse me. YouTube user Christopher Davis says, hi, Vincent. Not sure why I'm not able to set a reminder for your live stream videos, or do you not schedule them anymore? This I scheduled. I scheduled this, but I scheduled it like around 11 a.m. today. YouTube user John Doe KCK says, hey, Vince, good to catch you live. Hope all is well on the farm. It is. Thank you for checking in. It's good to catch you. Looks like Trump EOC is even worse than we could have imagined. Oh, well, you folks are the best. John Doe KCK, let me tell you, it is a mutual admiration situation. Choose Compassion is posting our retaliation playlist because somebody asked a question about retaliation. Thank you, Choose Compassion. You are a delight. YouTube user iTube, lowercase iTube, says, if my employer declines early ADR, alternate dispute resolution, what can I do to get them to mediate before it goes all the way to trial? I'm seeking reinstatement and can't wait 2 years. Uh-oh, chat jumped on me. Chat jumped on me. Chat jumped on me. I got to find the question. I can't wait 2 years to get this resolved. Yeah, well, you don't need a mediation. You can just make a settlement demand. One good option. Derek Adams says, not to be confused with Eric Adams, the allegedly corrupt mayor of New York City, how long does it take to get my settlement checks after signing a release? In New York State, generally about 28 days. Corey says, if I have a retaliation discrimination case, how is the breakdown on settlement? How can I prove I was retaliated against? Get me more money. So Corey, down below, I believe that YouTube user Choose Compassion has posted our retaliation playlist. I would hit that up. I would also hit the damages calculation playlist. Also, I think I have some information in my frank settlement discussions with your attorney about getting punitive damages from retaliation claims in settlement that you might want to check out. All right, we have been interrupted. We have a $10. Why are people giving me so much money? You're all so generous and so wonderful. You don't have to give me money. I'm trying to answer the questions for free. Okay, YouTube user OK Station, thank you again for the $10. Why would the HHS Health and Human Services, changed mediators the day before my mediation was supposed to reconvene, ended with a $50,000 settlement refusal, and the mediator said they may need to get more funds authorized to settle. I don't know why they might change. They might change because the person was busy. They might change because they don't like the way the mediation went. I don't know why they might change. I will say, it sounds like things were going fairly well because you were saying no to 50 grand, and the mediator sounds like on your side, saying the other side's going to have to get more funds authorized. That's very positive. So I hate to see the new mediator come in and maybe not agree with that, but hopefully they do agree with that. Okay. Let me find where I was in the chat. Where was I? Okay. YouTube user Christopher Davis says, I told you once that I have a mediation session with the EEOC and my employer scheduled next month. It's been nearly 2 months and it has been extremely difficult to find an attorney. Christopher Davis, have you used our Find an Attorney playlist? There's videos in there about helping you pitch your case to employment attorneys. It can always be hard to find employment attorneys. There's just not enough of us. I'm really sorry. F16 Raptor says, hey, Mr. White. Thanks for these lives. Really helpful. I worked at the UPS store and I complained about sexual harassment via email, and they send me a separation form with 2 weeks of pay, and I want to get back to work. Well, hold on now. Did they send you an agreement with those 2 weeks of pay? Like, did you sign a release? Because if you didn't sign a release and you complained of sexual harassment and they sent you a separation form, that's not just a sexual harassment claim. That would I would say that is also retaliation claim. Mississippi Second Amendment guy says, thanks for the advice. Mississippi, my pleasure. Blue Collar Training says, I went to cooperate August. I think that's probably a typo. I went to corporate August 19th about faulty equipment, disrespect, and favoritism about my team lead. And I tried to go to HR August 16th, but it was ignored. So I went to the corporate after that, got fired October 11th. It's retaliation. So Blue Collar Training, if you complained of discrimination or sexual harassment or engaged in some other protected activity, and you were then fired as a result, that is absolute retaliation. Now, favoritism and disrespect, those are not necessarily discrimination, but they could be. So hopefully we're talking about discrimination here. YouTube user Corey says, does your firm charge more than 40%? No, our firm has never, to my knowledge, charged more than a contingent percentage of 40%. YouTube user Blue Collar Training, I got my unemployment letter. After it says fired for no misconduct. Yeah, I don't think you did anything wrong. That's why. Certainly, I'm glad you qualified for unemployment benefits. YouTube user Derek Adams says, how long till plaintiff receives a settlement check after signing a release agreement? Dealing with an insurance company, I was shot 5 times at a basketball gym. Well, Derek Adams, 1, I am super glad you're okay. 2, getting shot 5 times. Let me ask, did they mean to shoot you? Or was that an accident? I would hope that they meant to shoot. Not that I want someone to want to shoot you, but I hope if you got shot 5 times, at least I hope it wasn't just spray and pray. Boy, I'm glad you're all right. So listen, that's not an employment case. It doesn't sound like. It sounds like a very different kind of case. Everything I talk about in this channel is like workplace discrimination, workplace sexual harassment. You're asking me about something that I have no idea about. That's just a reality situation. So the answer I gave you, which was 28 days and how long it takes you to get paid, that's tied to like if you settle a workplace discrimination or workplace sexual harassment case in New York State. There's another $10 up here. What do we got here? Okay, I already answered this. For some reason, it's not like going away. So not that I want it to go away. Okay, station. I just want to make sure I answered it. Okay. YouTube user Blue Collar Training says, my EEOC appointment is next week for retaliation. Do I have a case? Do I have a case? Went to corporate after they got fired for late tardiness, filed for unemployment, says fired for no misconduct, and it was retaliation. Yeah, you might have a case. If you engaged in complaining about workplace discrimination or workplace sexual harassment, and then you were fired, that is a retaliation claim. That would go before the EEOC. So certainly it could be a claim. YouTube user Justin says, yes, I had a written agreement. Justin, if you have a written settlement agreement that you executed, you should talk with your attorney about taking that to court and enforcing it and getting your money if you want to. YouTube user Joe King says, King v. IC Group. Judge mentioned manifesto injustice and interlocutory appeal. Case is now closed in district court. Includes possible PPP fraud. What are the next possible steps with a brief explanation? Well, I have no idea because I haven't seen the docket. So you're telling me the case is closed. You're telling me that you might need to appeal. Looks like you're looking at a potential appeal. So you might need to file an appeal. I don't know what's going on. You're talking about manifest injustice, which tells me something went seriously wrong. And PPP fraud, which is those claims can be great. So I think you're going to have to I would screenshot your docket in the district court and take it to an appeals attorney along with the decision that closed your case and get an opinion as to what they think they can do for you. That's probably the next step. If you have counsel, I'd also have a lot of conversations with your current attorney as to what happened, why you are where you are, what's going on, what your options are. Those are the two things I'd recommend right now. Taking a short break to check my email because I've been going for an hour and 2 minutes. Okay. Excuse me. I just got to close up my emails for the day. All right. Back to the live stream. YouTube user Kansas City News says, if you serve the company and their employees and formal employee, is it too early to get the employee's contact information, or do you have to wait until discovery? Well, I mean, if you have a means to get it, go ahead, but you can get it in discovery later on. YouTube user Derek Adams, I think I already answered your question the best I can, so I'm not gonna keep reading it. YouTube user AR American says, hey Vince, if the defense requests a discovery extension, is that usually good for plaintiff? No, doesn't mean anything. Just means they want more time. Might mean they're busy. Okay, so OK Station added something else that I didn't see because it wasn't in the original question. OK Station had a settlement and they got up to a $50,000 offer, and they ended the settlement day. And it turns out that OK Station refused the $50,000 offer, was instead demanding close to $125K, which, awesome. I hope you get that money. So they assigned a new mediator for the second day, but I think it's very positive that you're getting the second day of mediation. And OK Station says, I know, man. I think he's responding to me saying you don't have to pay me. I really appreciate the information. That's very kind of you, OK Station. Thank you so much for saying that. It does feel ridiculous to sit alone in a room, right? And just like be talking into a camera. So when people say that the stuff is helpful, it helps a lot. It helps me to feel less ridiculous. Okay, this is an interesting one. Scott Niebarger says, have you ever considered how subjective performance appraisals can be at large corporations that share a bucket of money each year? E.g., your organization has X top performers, X average performers, and X below average performers. Do you go on? Is there more? All right, that's the whole thing. Yeah. So, yes. If you're asking me, have I ever thought about that? I absolutely have, because we litigated cases about disparate treatment discrimination claims tied to protected classes and how that pool plays out. That pool of performance reviews tied to bonuses, right? Incentive pay. AR American says, also, if defense counsel withdraws the defense from the case, can we file a motion for summary judgment and win? Well, you can file a motion for summary judgment if the judge says you can. You can ask for leave to file that motion. And if there's no trial necessary, there's no question of fact, which is generally the standard for summary judgment, then you would win summary judgment on at least some of those claims. But that's not necessarily like the withdrawal of the withdrawal of the defense counsel. What do we have? John Doe KCK says, so have you been flooded with intakes from U.S. government employees this last month? And have you reached out to Legal Eagle to see if you could be his go-to for employment law questions, which would drive traffic to your channel and maybe cases to your firm? I have, well, two separate answers. I'll go with Legal Eagle. I will go with Legal Eagle first. I do not know Legal Eagle. I have not conversed with Legal Eagle. I have seen a little bit of Legal Eagle's content, but not a ton of it. I'm aware of the Legal Eagle channel, and I would be happy to do a crossover with Legal Eagle or a collaboration. But I perceive that Legal Eagle's channel is way, way, way larger than my channel, so he may not want to, right? But that's okay. I'm not worried about it. And then the first part of the question is, have you been flooded with intakes from U.S. government employees this last month? Yes. Yep. Sure have. Okay. Marine Carrium says, can an employer be held to the inaccuracy in their position statement after the case is filed in federal court? So we have a video on the channel about how lies in the position statement are opportunities, and essentially we're talking about the same thing there. Yes, lies in the position statement are then things you can use to confront witnesses during depositions, things you can undermine with interrogatories, things you can attack with document discovery. Lies in a position statement are opportunities, and it's valuable. Okay. Ooh, chat jumped ahead. F16 Raptor says, appreciate it. I promise I'll send you some cash when I get paid because you deserve it more than my lawyer. F16 F16 Raptor, no need to give us cash. I appreciate that, but that's your money. You went through this. It's not my money. I didn't win it for you. The introvert. Oh, that question is deleted, retracted. Ajna Maladara says, I have a mediation in a few days without a lawyer. Watch our mediation preparation playlist. I'm still employed there. I'm just trying to negotiate a move. Okay, good luck. I would check out our mediation preparation playlist. I think it might help you a whole bunch. YouTube user John Doe KCK says, Vince, if somebody gets a right to sue letter from the EEOC, does the confidentiality that applies to the proceedings go out the window, allowing a petitioner to again run their mouth about how evil the former employer is? Yes. Well, especially like once you file your case in federal court, hypothetically, if you have a right to sue letter, you can file your case in federal court. At that point, you have a public filing, so you're already kind of out there, right? YouTube user OK Station says, is 40% common? I'm getting charged 40% for mediation. So OK Station, I see firms working as low as 25% and as high as 50% in various different jurisdictions. We're in all 50 states. We see a lot of different stuff. We see sometimes different fee structures in arbitration, different fee structures for different claims. Different firms have different fee structures. We see a lot. 40% is very common in this field. There's a lot of firms at 35, 38, and 40%. I would actually argue 35, 38, and 40% are like the sweet spot in this field. I often see the better firms at 35, 38, and 40%. Some of the sketchier firms are at 50% for, there's the money grab. And then a lot of the firms under 35%, some of them are under that because they can't get clients for whatever reason. So, check out that firm, evaluate that firm carefully. AR American says, if your lawyer says the case is a big mess, what can he be implying? Also, the defense lawyer is on his way out. Can that be good news? Possibly. Well, listen, a change of representation on the defense side is often a good thing because the transition can be a little difficult. In terms of your lawyer saying your case is a big mess, might mean that legally there's some legal questions that aren't playing out the way your lawyer wants for you. It might mean discovery didn't go well. It might mean your testimony or your witness's testimony didn't go well. I don't know what your lawyer might be referring. It could be multiple things. Like a big mess can mean that like a lot of things are wrong with the case. That's not very positive. So I would, have the conversation. That lawyer is your lawyer. That lawyer works for you. So if the lawyer is like, hey, this case is a big mess. Okay, dude. Or she or he, whoever it might be, why don't you give me a list? What do you think are the problems with the case? When you say it's a big mess, what does that mean? I'd like a list. Give me the details. Give me an in-depth analysis of what's wrong with my case. What's adding risk? What's the problem here? So I, Mr. AR American, can make an informed decision, right? That person works for you. They should be doing what you want. YouTube user Secret Dad says, my employer has a contract with the county. If a county employee persuaded my employer, they can be liable for discrimination. If a county employee persuaded my employer, can they be liable for discrimination also? Maybe. Depends on the employment relationship. Talk with your attorney about it. Check, with local counsel. But in certain situations, it could be, yes. So sorry, be blowing my nose on air. YouTube user Corey, if I take a case to trial and you ask for attorney fees, you get that plus a percentage of the client check. So Corey, we have videos about this on the channel. Different firms handle it different ways. Our firm, if we get awarded attorney's fees, we take that award of attorney's fees and we reduce what the client pays us out of their percentage by that award of attorney's fees. That is not always the case. Many other firms will double dip. They'll take the attorney's fees plus their full percentage. So check your retainer agreement. Make sure you know your rights. Make sure you know what to expect. Know your arrangement with the firm you're hiring. iTube says, should I wait for my former employer's position statement before sending a settlement demand? No, you don't have to. I want an attorney to help with my demand, but they won't consider representing me until after the statement. Well, that's unfortunate. I would say keep looking, but if you can't get representation, you can still make a demand without representation. Christopher Davis says, if I'm suing my employer for retaliation and discrimination during my mediation process, would it look away if I didn't choose to resign from the employer, but rather move to another department? Not at all. It's very common. Whoa, chat jumped ahead. Uh-oh, chat might have broken. I'm getting the little boxes again. Come on, YouTube. Get it together. We have YouTube user The Introvert Speaks. After multiple meetings and almost 2 years later, the final hearing is scheduled. Can you provide some advice on how I should prepare? Sure. So The Introvert Speaks, you have elements that you have to prove for your claims. You should find out what those elements that you have to prove are to win each of your claims. And then you should devise a plan for each of those elements as to what evidence you're going to show and present and how you will show and present it to prove each element of each of your claims. That is the simplest way to approach a trial or a hearing. Okay, I'm back. Are we all here? Did this successfully reconnect? Can someone tell me if we're successfully back? Oh, we're back. Thank you, Choose Compassion. That is great because last I guess Monday or last week, I don't remember which, the reconnect option did not work. So I'm glad that it worked this time. Okay. Oh, thanks everybody for the likes. By the way, we have 43 concurrent viewers. We lost some viewers because the tab crashed. Damn you, Firefox. Fine. Firefox is great. What do we have? YouTube user AR American says, if your former employer had a prior lawsuit with their own LLC and lost, is that helpful for other employees if they sued for wrongful termination? Maybe. Depends what was shown or presented in that case. F16 Raptor says, regarding the sexual harassment, my employer claims he got a third party to investigate, but it ended up being his lawyer. So they can have their lawyer investigate. I don't think it's the best idea for them, but they can do that. It in certain situations will fulfill the the affirmative duty to investigate. YouTube user CNote1906 says, hi again, and thanks, Vince. Hi, CNote. How long does it typically take for federal court in California to decide if your case or claims are dismissed after you answer the summary judgment motion for summary judgment? Thanks. So I'm going to answer in generalities without answering for California because I am not admitted in California, and even I'm uncomfortable even offering like a timing advice into California because I don't want to engage in the unlicensed practice of law, and I don't have local counsel here beside me right now, so I can't answer your questions about California law, nor should I. So in New York, if you get a motion for summary judgment, it's fully briefed. They file the motion, you file your opposition papers. I would expect to get an answer in 3 to 9 months. Depends on the judge, depends on the docket, but that's generally what I would expect. AR American says, what's the next best move I can ask my lawyer to make if the defense requested extensions and is also ignoring our initial demand and mediation requests? Well, I would have your lawyer move forward with discovery, potentially. Milwaukee Juniors Volleyball Club says, thanks, as always, Vince. Great information and reflections on each live chat. Thank you, Milwaukee Juniors Volleyball Club. It's very kind of you. YouTube user Yo-Yo Dime says, my employer sued me for filing charge with the administrative agencies. Your employer sued you for filing a charge with the administrative agencies. Is this a new separate claim or part and parcel of my underlying employment claims? I mean, it's certainly a retaliation claim, I would say. Talk with your counsel, but I would think that's a retaliation claim. Whoa. Okay. We are getting close to the end of the questions here. I actually caught up for once. YouTube user Happy Dog Day says, my husband was forced out of work and denied reasonable accommodations. His only option was to take a quit package or go on short-term disability, then go long-term and apply for SSDI. Should we sue? Well, if you took a severance package, you may not be able to. So what I would recommend is you speak with local counsel about the viability of those reasonable accommodation, those ADA, American Disabilities Act claims, and bring that package with you if you executed it so they can see what you're dealing with and see if they can still help you. But yeah, you sound like you might certainly have a claim. AR American says, why would my lawyer allow the defense more time? From what I understand, they had to sign to agree with the judge for the extension on discovery. Isn't that a bad move or a disservice, or is that common? AR American, granting extensions, at least at the start, 1 or 2 extensions is very common. It is considered courtesy. If you don't do it, the judges will smack you around pretty hard, frankly. It's called sharp practice. And that person is going to get the extension anyways. Your attorney is just going to make you and he or she look bad. Wendy Lederer says, why are victims of workplace abuse who win settlements against the employer forced to pay tax on the money? What is the point of going through it all if you just have to give half of it back? Well, you're not giving half of it back, for starters. I mean, listen, I don't know what tax bracket you're in, but generally speaking, it's not half. Why do you have to pay tax on that money? So there's a philosophical answer, and then there's a technical answer the government would want me to give you. The philosophical answer is that you vote for bad people. And not you, Wendy, but like the people who vote for Republicans or Democrats are part of the problem, right? So like neither one of the political parties are filled with good and caring politicians who lead in a thoughtful, respectful, or humane fashion. They tend, generally speaking, to be corrupt if they're involved in one of the major parties. So we elect really, really questionable politicians. They then enact really questionable laws that do things like tax victims of sexual harassment or workplace discrimination. And we have what we have. That's the philosophical kind of global answer. Now, the government would want me to say, well, Wendy, we must tax a settlement of a sexual harassment or workplace discrimination claim because some part of those damages are wages, and they must be characterized as wages because they're wages being paid, and we have to apply all the government taxation to them because that's how compensation works in our fine nation. And the social safety net and the wonderful government that you enjoy as a citizen of the United States, it's not free, Wendy, and you must pay into it. It's part of the social contract. But of course, there is no social safety net, and the federal government doesn't do much besides transfer wealth from the poor to the wealthy and engage in insider trading and in endless wars of foreign aggression. So, Wendy, I'm with you on this. We should give them less money. But that's their answer. Sorry if I got political there. Elmo 454SS says, what about if you win a case? It was a big settlement. And now at your old new job, and now at your old new job are in an assimilated situation. Should I go forward? I was fired for no reason. Okay, I'm gonna try to translate. Elmo, type a check next time. So it sounds like you settled the case. You didn't win it, you settled it. You got a big settlement. Congratulations. Now you're at a new job and you're in a similar situation. Should you go forward? Well, if it's a good claim, I don't see why you wouldn't. But if it's not a good claim, then no. Talk with your local employment attorney to see if it's a good claim, right? Happy dog days. Then if he did not take that severance package, I would absolutely talk with local counsel. You might have a great claim. NYC Damages says, hi, Vince. Great to see you again, helping us here. Thank you. Thank you, NYC Damages. I hope you're about to have a lovely weekend. The YouTube user BCM4134 says, I was discriminated against, fired, and defamed on the public internet broadcast over multiple internet channels by my ministerial employer. Do you think ministerial exception would block my tort claim? I don't know. Ministerial exemption is a hell of a drug. It really causes hell with these claims. But first and foremost, I don't think the ministerial exemption does much in terms of blocking a defamation claim. So right off the bat, talk with your attorney about that. But in terms of a discrimination claim, it's going to be a big question of why you were discriminated against, right? Like, that's what we're talking about here. How does that discrimination tie into your ministerial exemption? Because, like, there's not too many faiths in the world where, like, a race case, like a race discrimination case, would be blocked by ministerial exemption, right? There's definitely cases where, like there's Christian sects where, like, if you have a claim for sexual orientation discrimination, they can argue ministerial exemption, and that might stick, right? Because they might say, well, in our faith, we teach that it's against God's law to be gay or to be bi or whatever it is. Now, listen, I deeply, deeply disagree with that. I think that's an immoral stance to take, but, like, it is their faith and they're allowed to some extent to pursue their faith. So there's this thing called ministerial exemption that lets them exercise their faith in the course of their employment somehow. DJ ASEX says, heart to you, DJ. AR American says, can you elaborate on that, please, regarding what to tell him to do since the defense is still ignoring us with our requests? Okay, so if you have discovery requests already out, you've already made your discovery demands, you can do a motion to compel to force them to comply with them. Now, you can't do it faster than the judge will let you schedule discovery, like, deadlines. But if they're not complying with the discovery deadlines, you can make a motion to compel. Okay, YouTube user Sonia Underwood says, I told him, every time I see the username Underwood, I think of House of Cards. I told him you could have just told me over the phone or sent a letter. So I asked him, what is the union? Sonia, is this the first part of your question? Because it seems like you're starting in the middle of a thought. Okay, I don't know. Okay, I told him you could have just told me over the phone or sent me a letter. So I asked him, what is the union doing on my behalf? Because I'm still paying dues. Can unions be sued for retaliation? Yes. Yes, they can. By His Grace says, does the court system portal update when the complaint has been served to the RA 2 months in and no update? Well, if your attorney perfected service, they would have to file proof of service to have it update in the portal if you're dealing with the ACF system in federal court. YouTube user Happy Dog Days. Thanks again, Vince. I'm subscribing. Happy to have you aboard. Happy Dog Days. I hope you and your husband get paid. Oh, Sonia, your comment was chopped. Got it. Excuse me. Okay. We're getting to the end here. We've been going for about an hour and a half. Kansas City News says, what is the number one thing to say to the insurance company to boost your claim when they offer $1,000? That's fine. I mean, I think I would say that's fine. I'll take the case to trial. Would be a good place to start. Wendy Lederer says, thank you. I didn't vote for either side. I wasn't taxed on all of my judgment, but it's a lot to me. I'm in the lowest tax bracket. Wendy, so first off, if you had an attorney, you should not pay taxes on what your attorney received, ever. So, like, make sure you're dealing with professional tax counsel there. Two, I get it. You didn't vote for either party. Neither did I. They're villains. They're villains, aren't they? They don't mean us well. I'll tell you that. I'll tell you that much. Sam K says, hi, Sam K. How you doing? YouTube user CC says, just FYI on settlements and taxes, talk to your tax person. Great advice. And not a seasonal H&R Block type tax person. Ask them about settlements, taxes. It's all about the settlement language. Correct. NYC Damage, did you ask a question? I think I found it. NYC Damage says, and what if you filed and the discrimination is ongoing? Do you file with the EEOC again for ongoing issues? How about retaliation again? Now for filing in court. Okay, so as the EEOC, the Equal Employment Opportunity Commission, charges open, or New York State Division, whatever it is, you can keep amending as more things happen. There will come a time where they say to you, hey, we're not going to let you amend anymore. You got to open a new case. That's fine. Do that. Now, keep in mind with the EEOC, if you're going to go on to federal court, you need everything filed in the EEOC so you can get a right to sue for all of it. Now, the EEOC right to sue will cover anything that reasonably flows from the facts that you already filed. But I'll be frank with you, it's better to have everything filed explicitly rather than have to later argue, hey, this reasonably flows. Will you be successful with that argument? Probably. But why introduce risk, right? So NYC Damages, I hope that answers your question. By His Grace, YouTube user By His Grace says, it's state Connecticut, so my attorneys update the system and not the clerk or the CTS. So your attorney has to file proof of service if you're in federal court, generally speaking, and then the system will update. But like the process server doesn't magically upload proof of service. They bring proof of service to your attorney, and your attorney uploads the proof of service, and then the court is aware of it. The BCM 4134 says, I was a church musician. That can be tough. Working with a church can be tough. Oh, By His Grace, state court in Connecticut. I don't know. Can't answer your question. I'm not allowed. And also, I don't like Connecticut. I have to drive through Connecticut twice a week, every week. I don't care for it. Not a fan. I got to drive 91. I got to drive 95 twice a week. I don't like your roads. I don't like how you deal with traffic. I don't like how you deal with road construction. I'm a little riled up about Connecticut these days. I'm kidding. Connecticut's lovely. YouTube user NYC Damages says, the EEOC right to sue and filed in federal court. Ugh, bad connection on my end. Okay, so if more stuff's happening and you're in federal court, you have a period of time to amend as a right. You can amend to add the additional facts in. If you're outside the period of time to amend as of right, you can ask for leave to amend and amend. But if it's too late to amend or the judge won't give you leave to amend, you can file a new EEOC and have a new case. By His Grace says, LOL, no LOL. It's state Connecticut, my friend. Not sharing what state. Oh, state court. CT, state court. Okay, got it. Understood. So listen, state courts operate different. All state courts are a little different. You can't say like this is in and this is, you shouldn't know this. There's no reason you would know this. I'm not berating you. If you say, hey, I'm in state court in some random state. How does this happen? The real answer is, I don't know. Because even if I knew how it was done in the state that you're in, I don't know which state you're in, so I can't tell you. Also, I'm not allowed to answer about state law questions. I got to answer as to the federal laws, which I can answer. They pen through the EEOC, so I can answer all 50 states, right? Happy Dog Days. Do you have any recommendations for employment attorneys in Tennessee? I do not. But I know there's a couple. Because people who hire us out of Tennessee have talked to usually 3 to 5 attorneys before they hire us out of Tennessee. So I know there's at least a couple law firms in Tennessee who do this. iTube says, when I make a settlement demand, should I go as high as possible? You should go as high as you can without ending the conversation. I feel emotional damages and back pay are deserved to me. And that's if you want a settlement, right? If you don't want a settlement, then don't worry about that. But if you want a settlement, you should go as high as you can without ending the conversation. I feel emotional damages and back pay are deserved to me, but most importantly, I just want reinstatement. So that's really important. If you're getting reinstatement, your case is going to be worth a lot less because the damages will get cut off, right? Ajna Maladara says, any advice going without a lawyer? Don't do it. If you can avoid it, don't do it. Representing yourself pro se, representing yourself at all is just an act of self-harm and self-hate. I'm sorry to say it. Listen, there's people on this channel who've done a good job. No question. There's people on this channel who have done a good job. But it's super hard, and representing yourself adds so much risk. YouTube user Bucket Chaser says, hi, Vince. Can you speak on how to determine emotional distress through the multiplier? I read somewhere that it starts at a rate of 1.5x to 3x. Through the multiplier. Can you speak on how to determine emotional distress through the multiplier? What are you multiplying? Did you mean economic damages? Like multiple years of economic damages, or you're specifically saying emotional damages? I don't know, Bucket Chaser. I'm sorry. I actually don't know what you mean there. I apologize. Your non-economic damages, your multiplier for non-economic damages. What are you multiplying? And just for the record, Bucket Chaser's question, the last question, I'm trying to understand the question just so I can get the best answer. Okay. So I'm going to read what AI says to Bucket Chaser's question. The emotional damages multiplier is a number between 1.5 and 5 that's used to calculate a settlement for emotional distress. The multiplier is based on the severity of the injuries and the duration of distress. How it works: add up all economic damages, such as medical bills and lost wages, multiply the total by the multiplier. The result is the proposed settlement amount. I don't think this is, I think you're quoting. Yeah, that's how you do it in personal injury lawsuits, Bucket Chaser. That is not how you determine emotional damages. That is not how you determine emotional damages in an employment law case. So I just pulled it up. That is specifically in personal injury. It is different fields. Soulful Geocacher says, hi, Vince. Just want to say hi and thank you. Soulful Geocacher. I hope you're finding good geocaches. Sonia Underwood says, you are so smart, Vince. No, I'm super dumb. I only know one field, little tiny field. I keep it real simple. But thank you so much for saying that. Okay, everybody. Have a great weekend. We've been going for an hour and 35 minutes, an hour and 36 minutes. I had a lot of fun. I think I'm going to do a little skiing tomorrow. Going to cook some food. Happy Dog Days. We take cases in all 50 states. You are welcome to contact our intake people, but I always suggest you check your local counsel options first. Local counsel can be really great, equally great as we are. I think we're swell, but they can be just as good. And they are often cheaper. So check your local your local attorney options first, and then we're here if you need us. Yeah, lost wages. You often use the multiplier for lost wages and economic damages in employment cases. The emotional damages multiplier, from what I just pulled up, is for PI cases in certain situations. That being said, everybody, I'm out. It was wonderful speaking with you. Thank you all so much. I think we had a really high concurrent viewer. We have 59 likes on the channel. That really helps us out. It helps us be seen by the algorithm. I hope we answered some questions. I enjoy you all very much sincerely. Like, I'm going to just say, I'm typing, thank you all. I had fun, and I did. I did have fun, which is wild because I'm working here, right? But I had fun. Take care, everybody. Have a great weekend.